Dr. Anup Srinath, and I head the death penalty research project here and the death penalty litigation clinic here at MD. The research project is since June 2013 in collaboration with the National Legal Service Authority, interviewed all of India's death row prisoners. We've interviewed their families and we've interviewed their trial court lawyers. And the litigation clinic since August 2014. We now represent nearly 35 death row prisoners in various courts at various stages of the processes. What I'm going to talk about today is, I'm not going to focus too much on what we have found through these interviews and things of that sort, and I'll talk about that if it comes through any of the questions or clarification that any of you have. What I'm basically going to do today is sort of take you through the sort of very problematic sentencing practices that the courts have adopted and look at the Supreme Court on why the current state of death penalty sentencing is completely crisis-ridden and is unreliable, and we really need to worry about the state of that legal discourse. One, and secondly, in the second part, I'll take you through the sort of very important developments in procedural reformation of how the death penalty has been administered, and through that I'll take you through the issues that remain to be settled after Shatrughan Chauhan, Mohammad Arif, and Surinder Kohli's case, Allahabad High Court, and recently the case of Shabnam versus I think all of you must be very familiar with the critique of the Supreme Court that it is inconsistent in the application of the rarest of the rare doctrine, and I think that inconsistency is as much doctrinal as it is inconsistency arising out of application on a case-by-case basis. And I think it's the problem of doctrine that's fundamentally problematic, and I think the subsequent problem that we are not applying it consistently comes later, because I don't think now the court is very clear about, and neither are the judges very clear about what is the test, right? And of course, the moment you raise this question, everybody says, of course, the test is the rarest of the rare doctrine and Bachan Singh, but what does it really mean? And what does rarest of the rare doctrine mean in Bachan Singh, and how has it been applied? How has the doctrine been understood in the subsequent cases after Bachan Singh? As all of you are aware, in Bachan Singh, they drew up this framework and they said, and I think there's a very foundational misconception of what rarest of the rare means. In Bachan Singh, rarest of the rare was never meant to, the phrase was never meant, and if you read it very closely, is never meant to indicate a rare, heinous crime. The rarity of what is being referred to in Bachan Singh does not refer to how gruesome, it does not attach itself to how gruesome the crime is or how rare that kind of crime is. That's not what the test of rarest of rare is. The rarest of the rare crime, the doctrine is meant to indicate that we should try and it is meant to restrict the category of cases in which and the kind of cases in which the death penalty is imposed, and then I think and there's a problem with that, and that comes out in Machi Singh, and I just get to that. Now in Bachan Singh, again there are list of aggravating circumstances and a list of mitigating circumstances, and the question perennially has been, and courts have grappled with this in terms of what is to be given priority, and I think in Bachan Singh it's quite evident that it is an act of balancing and not merely an act of saying there are 5 aggravating circumstances but there is only 1 mitigating circumstance and therefore the death penalty has to be given. No, it's not meant, it is meant to be an act of balancing rather than being a balance sheet. right? And the courts grappled with this for a really long time about adopting this balance sheet approach, which has sort of seeped down into the high courts and the trial courts even now, while the Supreme Court itself has recognized its mistake and quite explicitly recognized its mistake. But this balance sheet approach continues to plague lower courts in terms of just saying, okay, we're going to, Bachchan Singh requires us to drop these two lists and then compare which entry, which column has more, and therefore then decide the death penalty on that basis. I think if you were to read Bachchan Singh closely, you would see that that's certainly not what is expected. It is an act of balancing that is required. So that's and I want to highlight a couple of factors that they do say are mitigating, right? Now, factors 3 and 4 in paragraph 204 of the Manupatra version, you will see those are two factors on which the obligation is placed on the state, right? The first obligation is that the person in question is a continuing threat to society, right? And that obligation is placed on the state. The state has to prove, if the state is asking for the death penalty, the state has to show the court that the person in question is continuing to be a threat to society, right? It is not, the obligation is not on the prisoner to say that he or she is not a threat to society anymore. The state has to show it, right? Similarly, the state also has to show, right, that there is no question of reformation and rehabilitating this person, right? That there is no question of, and the state has obligation to show, right? Now, and this has been, these two factors have been completely ignored in the jurisprudence of the court, that there is no demand made on the state to show any of these two things, right? It is, we are so caught up in the gruesomeness of the crime and what sort of collective conscience of the society and shocking the collective conscience of the society, we are caught in that framework, that nobody has really paid any attention to these two factors until a recent there was a recent judgment of the Delhi High Court in Bharat Singh, where a welfare officer was appointed to go and determine if Bharat Singh, who is about 65 years old now, continues to pose a threat to society. He's convicted and sentenced to death for rape and murder of a minor. So Justice Muralidhar asked a welfare officer to be sent to look into this. Now, how do we? Now the problem with this framework, with what Bachchan Singh laid down, became, I think Machi Singh started off in 1983. Machi Singh started off the problem, right? It started this whole process, which would take up until 2009 and coming in Santosh Barya to really recognize. So about 20 odd years, 26 years, there's then errors being committed on how this framework is being applied, and what happens in Machi Singh, and Machi Singh, in Machi Singh you see these, what is being imagined as a very relative category, right? It is saying you have to look at various circumstances, you have to look at special circumstances, you look at mitigating circumstances, you look at aggravating circumstances. Clearly in Bachchan Singh, they avoided trying to lay down a set category of crimes for which death penalty would be given, right? They avoided that. It is very clear they don't want to go down that road and say, these are the categories of crimes for which we will give the death penalty. But that is exactly what is done in Machi Singh, right? In Machi Singh, 5 categories are drawn up, right? 5 categories of murders are drawn up, and you can go through those 5 categories. And they say, and now there is a sort of concretization of the categories of crimes for which the death penalty must be given, which is something that the Constitution bench in Bachchan Singh has sought to avoid by building this very relative framework that the crime in that the question of deciding whether death penalty must be given for a certain crime and to a certain prisoner is very much a relative exercise. There is no question of drawing up a category and saying that we are going to remove discretion of judges by saying that these are the categories or the 5 categories of crime for which death penalty must be given. And then we move to Ravji, where then this misunderstanding is complete, right? In Ravji, it is held that in 1996 that it is only the circumstances of the crime that are relevant and not that of the criminal, right? And that completes this misunderstanding that started with Machi Singh, right? Of focusing only on the crime and no longer on the prisoner, and saying that you need to look at the circumstances, the brutality, the gruesomeness of the crime to determine whether the death penalty is given. And it is not relevant really to look at the circumstance of the criminal. Now, in complete contradiction to what is being laid down in Bachchan Singh, right? Now, you must understand that the problems of these problems are not limited in that sense to the Supreme Court, right? These seep down, and Ravji continues to be even cited today by trial court judges while sentencing people, right? While the court itself, and we'll come to those cases, while the court itself has said Ravji is per impute, right? But, and I think the Supreme Court sending these conflicting messages is not problematic of cases being inconsistent in the Supreme Court. It is problematic because it is used in a vast majority of cases in courts below. Right? And then people are kept on death row for many years together until, I don't know how many years it takes for the cases to come to the Supreme Court and they get a commutation or whatever. And then I guess as per what we have looked at, the figures are that for every 100 cases that you get, for every 100 death sentences in a trial court, it's only about 3 or 4 that ultimately get confirmed by the Supreme Court, right? And that is not to say that the system is working, right? It is proof that the system is broken, right? It is proof that people are kept on death row unnecessarily for very long years, merely because we haven't sorted out the legal framework and the legal doctrine with sufficient clarity. So now in Ravji you have this position being taken, right? That it is a criminal that needs to be that needs to be the focus. The crime that needs to be the focus in death penalty sentencing and no longer the criminal. Now, in starting with Swami Shraddhanand and Santosh Bariyar, and finally culminating in Sangeet, right? The court starts to feel uncomfortable with this entire discourse of saying that we need to sort of ignore the criminal. And there are about 14 cases that the Supreme Court itself in Sangeet recognizes that relied on Ravji to sentence people to death. And there are at least 4 of those cases still where people continue to be on death row because of its reliance on Ravji, right? For various reasons, those cases are not brought before, they are not currently being litigated before the Supreme Court, right? But the court itself in Sangeet recognizes that it has committed an error, right? And the Supreme Court itself has relied, and they list in Sangeet the 14 cases that have wrongly applied the law in Bachchan Singh by relying on Ravji, right, and sentenced people to death, right? And then you see this move back to saying, okay, how do we really apply this test? And you see that in Shankar Rao Khade, right, a 2014 case, right? Now in Shankar Rao Khade, right, that's 2013 5 SEC, right? In and now, and you will see how it goes, it swings to the other extreme. In Shankarrao Khade, they are saying that this crime-criminal test, the crime test has to be satisfied 100%, right? That is the aggravating circumstances. But even if there is, and the criminal test has to be 0%, that if it is anything more than 0%, that you're looking at the circumstances of the criminal, right? If it is, it has to be 0%. If it is anything more than 0%, you can't use the death penalty, right? Now you see the two extremes. If you have Ravji on one hand and you have Shankarrao Khade on the other hand, where in Ravji they were very clear that only crime, right? You will look only at the crime and you will not look at the criminal, and a whole host of people were sentenced to death on that basis, right? And continue to be on death. By the time you come to Shankarrao Khade in 2013, the court has swung to the other. I mean, when I say court, one bench of the Supreme Court has swung to the other side to say what? To say that in comparing the aggravating circumstances, which is more in reference to the crime, and looking at the mitigating circumstances, which is more in reference to looking at the circumstances of the criminal, crime has to be satisfied 100%, but criminal has to be 0%. If you want to give the death penalty, right? I don't think that's an accurate reading of Bachchan Singh, right? And my own view on Bachchan Singh is that if it is actually followed, right? If at all we were to have, if at all we were so insistent on having the death penalty, the framework developed in Bachchan Singh, if followed, is perhaps a very, very high standard, and it's very difficult to give death under the Bachchan Singh standard. If you were to actually follow those circumstances, particularly those points where the state has to lead evidence, where the state has to lead evidence that this person is a continuing threat to society, right? And that this person cannot be reformed and rehabilitated, right? Now, if you, and I think as if courts were to be very clear about that, you would not see these many death sentences being handed out every year, right? And I think in 2014, I think the number was about 74 death sentences by trial courts across India. Now, so that's, I mean, that's in very short the sort of doctrinal inconsistency in what the Supreme Court has developed on giving the death penalty. And this is not talking about similarly situated cases where in one case it's a rape and murder of a minor and the court has given death, and in another rape and murder of a minor the court has not given death. I am not on those steps. And that is a very, very large category of cases where on such comparisons, on facts, you will see that the court is inconsistent. What I've been talking about so far is doctrinal inconsistency by different benches of the Supreme Court. And of late you don't, Shankarrao Khade is 2013, but in subsequent decisions of the Supreme Court confirming death sentences, you don't see Shankarrao Khade being applied, right? In all, the current Chief Justice, probably has given more death sentences than any other Chief Justice in the history of this country by confirming death sentences for 10 persons since he's become the Chief Justice, right? There is no use of Shankarrao Khade or, and I think this, it has become now doctrinal cherry picking in the Supreme Court, right? If it goes before, clearly before somebody like Madan Lokur, you would get a very, very different approach. Doctrinally, and I'm not on, again, I keep repeating this, I'm not on inconsistency arising out of facts. I'm not on that. I'm just on doctrine. There seems to be a far deeper problem within the Supreme Court on what the court is doing in terms of when it says it can apply the death penalty and when it can't apply the death penalty, right? So a bridge between this and the next part that I wanted to talk about is in limine dismissals of SLPs in the Supreme Court. In terms of, now I just want to move to reforming the processes which are used to sentence people to death and execute people. While I move, the bridge I want to use is in limine dismissals in the Supreme Court. Surely under Article 136, the court has the power to decide which SLPs it will admit and which SLPs it will not admit. But in the last decade or so, in about 10 cases, the court has dismissed appeals, SLPs in limine, and that is highly problematic, right? That the Supreme Court refuses to hear the appeal of a death row prisoner. And that becomes problematic even if you look at the kind of ridiculous SLPs that it does admit, right? Well, clearly the court has the time and the inclination to hear all sorts of other SLPs, which is not worthy of a constitutional court, right? It boggles the mind as to why certain judges would take the position that death penalty SLPs will not be admitted, right? They don't take a principled position. It's on a case-by-case basis. They just don't admit it. They throw it out, and they don't hear the appeal, right? Now, this is a very curious position, given what was decided in Muhammad Arif in May 2014, right? Where the court recognized a constitutional right, a fundamental right under Article 21, that all review petitions, right? Review petitions under 137, the court has the power to review its own judgments, as you all know. And the practice, as you all know again, under the Supreme Court rules used to be that review petitions would be decided in chambers. Review petitions are never decided in open court. So in chambers, review petitions are presented before judges, and they can decide if they want an open hearing or not. That used to be the position. So until this case was filed in Muhammad Arif is sentenced to death in the Red Fort attack case, right? Where the court took the position by a constitution bench by 4 judges to 1, with Justice Chalameshwar dissenting. Rohinton Nariman took the position that review petitions in death penalty cases occupy a special position, right? And now all review petitions in death penalty cases will be mandatorily heard in open court by 3 judges, right? So here you have a position now where while your SLPs may be dismissed, right? Your SLPs might be dismissed, your appeal will not be heard, but you have a constitutional right you have a fundamental right to an open hearing of your review petition, right? And the latest, and this is not in limine dismissal of in some bygone era. In January 2015, the Chief Justice dismissed in limine appeals of 3 persons in one case arising out of rape and murder, the gang rape and murder of a minor from Madhya Pradesh. From all reports, the Chief Justice was aghast at the crime, but perhaps the Chief Justice forgot that that's quite irrelevant to deciding the issue at hand. But anyway, that's the way these things play out. And so you have this dichotomy where now the court is, on the one hand, is very open to dismissing SLPs in limine, but has now put itself in a position where it's saying that there's a fundamental right to open hearing in review petitions only in death penalty cases, because death penalty forms a special category, right? So before the decision in Arif came the decision in Shatrughan Chauhan, which I'm sure all of you heard about, which dealt with how should mercy petitions be decided? How should the president decide mercy petitions, right? Now, once the president, the question was, can the court judicially review, can the Supreme Court judicially review rejection of a mercy petition, right? The court took the position that that it can, that while it cannot substitute its opinion for the opinion of the president, right? While it cannot substitute its opinion for the opinion of the president, what it can look is into procedural requirements of how the president reached his or her decision in deciding the mercy petition, right? That there cannot be undue delay, there cannot be unexplained delay. All relevant factors should have been placed before the president. The president should not have taken irrelevant factors into consideration, right? All the procedural safeguards, like the MHA, the Ministry of Home Affairs guidelines on how mercy petitions are to be considered should have been followed. Supervening circumstances should be placed before the President of India. And my favorite story on this is Dharampal's story. Professor Pandey has heard it, so excuse me for repeating it. So those, I don't know if those of you from Haryana might have heard of Dharampal's case. Dharampal was first, he was sentenced to death for killing about 7 members of a family. But the case started with a girl from that family accusing him of rape. He threatened the girl and the family not to proceed with that rape complaint and rape case, but nonetheless, the father of the girl and the girl herself went and proceeded with the case. He was convicted for that rape in the trial court. But when he went to the High Court gave him bail. The very day that he got bail and came out of prison, he went straight to the family and finished them off. And that he's never denied that. And then what happens is then he's sentenced to death for that, and the trial court, the High Court, the Supreme Court, all of them confirm his death sentence, and the mercy petition is sent to the president. But while all of this is happening, the High Court has acquitted Dharampal in the rape case, right? But nobody has bothered to mention this to the Supreme Court or bring it to the attention of the president, and the mercy petition before the President of India was pending for a good 17, 18 months. Right? And it is only now, I think only last month, that Dharampal's death sentence comes to be commuted by the Punjab and Haryana High Court. A, for delay and not for taking into consideration the supervening circumstances. He's kept in solitary confinement. So anyway, it just shows that the system is not geared, and having worked on this for a good 2 years now, I've come to the realization that it's rarely ever malice that prevents government officers or prison officials. It's just a certain level of bureaucratic callousness that the head does not know what the tail is doing, that causes this kind of complete lack of information flow, right? That leads to tremendous suffering for these prisoners in many cases. But anyway, so in Shatrughan Chauhan they said the courts can review the decision of the mercy petition taken by the president. It can't be a substantive review. It is very limited review. It's review only on administrative law grounds, and in those cases the court can commute. Right? The court can commute a death sentence to life. What Shatrughan Chauhan leaves open, however, is whether the same would apply when the president grants mercy. Right? Whether you would make the same arguments, right, when the president grants mercy. All petitioners in Shatrughan Chauhan where the president had rejected mercy petition. Now the question that Pinky Virani raised in another context was she wanted to challenge the grant of mercy, right? I think she's filed a petition which has never come up for hearing, was that where mercy is granted to people who have raped and murdered minors, that in those cases mercy should never be granted. And the question is, would you apply the same logic in Shatrughan Chauhan of reviewing president's decisions on mercy petitions also when mercy is granted? That I guess it will become to be determined at a later stage by the court. I mean, if Ms. Virani decides to pursue it, that petition. And then they lay down guidelines very strictly so that what happened in Afzal Guru's execution will never happen again, right? It was, I think, completely unacceptable in a rule of law society about the manner in which Afzal Guru was executed in secrecy, and the court lays down a whole bunch of guidelines on the last meeting, the intervening period between the death warrant being issued and when the execution can be carried out, last meeting with the family, time for the prisoner to finish, to tie up what they call as earthly affairs, that there must be legal aid, given to the prisoner while the mercy petition is being drafted, and not the completely pointless exercise that is done these days. I mean, the jails just send out this format. They have a typical format of a mercy petition. All that they do is they enter the prisoner's name and just send it off. That's what's done. Nobody really advises death row prisoners on what to put in the mercy petition, what not to put in the mercy petition. So the whole host of guidelines in Shatrughan Chauhan on these issues, on what is to be done, what are the guidelines, when the mercy petition is rejected, what is to be done after that. And their last guideline is quite interesting and quite macabre, to be honest, where they say that after you hang, if anybody is hanged to death, there must be a post-mortem conducted to determine if the person died by breaking of the neck or by asphyxiation. Right? I guess it is, I don't know, I mean, it is interesting to think of why the court would put that in. I guess it is for the court to see at a much later stage whether hanging is a cruel and unusual punishment. Right? People die more of asphyxiation rather than breaking of the neck. Right? So anyway, so that's, and then you come, and that's in January 2014. In May 2014 is Mohammed Arif. In Mohammed Arif, as I said, the review petitions are in play. Then they establish this fundamental right. And then, and interestingly, all the cases that have been now filed, so far that have been filed under Mohammed Arif, they also said that when review petitions have been previously been dismissed, where review petitions have been previously been dismissed, they can still be brought back for open review. But to this day, the court has heard about 3 review petitions post Mohammed Arif, in none of which the petitioners have been successful. Interestingly, in Mohammed Arif, they also said that if your curative petition has been dismissed, right? In all the cases where the prior cases where the review petitions have been dismissed, they said, however, if you went ahead and you have filed your curative and your curative has also been dismissed, you will not get the benefit of Mohammed Arif, right? You cannot come back and then ask for your review petition to be heard in open court, right? So it so happens that Mohammed Arif, that applies only to Mohammed Arif, and the 4 other petitioners in that case get the relief except for Mohammed Arif, right? Then we come to the third important case is that of Surinder Kohli's case in the Allahabad High Court, the writ petition that was filed in the Allahabad High Court after Surinder Kohli's mercy petition is rejected, on the guidelines that must be followed when a death warrant is to be issued. Now, what is a death warrant? A death warrant is when the sentencing court issues a warrant determining the day and date of when the prisoner is to be hanged. The exact date and time and is determined in a death warrant. The practice used to be that the prisoners never used to be given notice, they never used to be taken to court, they were never represented in these death warrant hearings. It was to be done very mechanically. So Justice Chandrachud in his judgment said that natural justice has to be followed in this. Prisoners have to be given notice, they have to be given legal aid if they do not have a lawyer, even in a death warrant hearing, right? That these guidelines have to be followed even at that stage. You can't argue that death row prisoners do not have any rights at that stage, that the rights inhere in them even till the very end, right? So, and this judgment of the Allahabad High Court received the approval of the Supreme Court in Shabnam and Salim's case a few days back, right? The court affirmed these guidelines, where in Shabnam and Salim's case what had happened was the death warrant was issued merely 6 days after the Supreme Court dismissed the criminal appeal. The judgment of the Supreme Court in their criminal appeal came on May 15th. The death warrant was issued on May 21st by the sessions judge in Amroha, asking that they be executed as soon as possible without prescribing any date or time. It only said execute them as soon as possible. That death warrant was struck down, and they said you cannot have death warrants worded like that, and neither can you have a death warrant when they have so many constitutional and legal remedies remaining, right? So that was so we see the court on the one hand grappling with this, and in essence what I want to say is on the one hand you see the court grappling with this doctrinal inconsistency, and on the one hand you see the court taking very progressive steps to reform the process by which the death penalty is administered, at least in the later stages, right? Without really grappling with, without ever really settling its doctrinal problems, right? Be it Shatrughan Chauhan or Mohammad Arif or Surinder Kohli or Shabnam, these are all very progressive judgments, far ahead of what comparative jurisprudence is, right? Especially the position taken in Shatrughan Chauhan that the problem with inordinate delay, keeping a person on his mercy petition pending for an inordinately long time without no reason amounts to torture, right? It's cruel and inhuman treatment. With the position that the prisoner need not lead any evidence to show that he or she has suffered during that long period, right? That suffering is assumed, right? And it is an extremely progressive position to take for a constitutional court, right? To say that, even if your mercy petition has been kept pending for 10 years, we're not going to burden you further. Given the profile of the death row prisoners you have, we are not going to burden you further and ask you to prove that you actually suffered in those 10 years. That there's going to be a assumption that this was torture, right? And I think that's an extremely progressive step to take. But unfortunately, we don't see this zeal for reform in a doctrinal sense within deciding this rarest of the rare framework and the exact terms by which the rarest of rare doctrine must be applied.